Well, it's 3 o'clock, so we should get started. Welcome all to the AB 1234 training. And this is new for me as well as all of you to be doing this over Zoom, but it's the pandemic, of course. I'm going to now share the PowerPoint that was all emailed to you all, and I'll give you some preliminary thoughts on today, and then we'll get started.
Uh-oh.
Okay. Can everyone see the PowerPoint on here? It says Ethics and Public Service.
Yes.
Very clear, Chris. Thanks.
Okay. Well, welcome to AB 1234 training. My name is Chris Newmeyer. I'm the Morro Bay City Attorney. And as many of you know, Assembly Bill 1234 has mandated ethics training for public officials, laws and principles for a number of years now. Upon assuming office, you need to do it within 1 year, and then thereafter every 2 years. So Morro Bay provides it every 2 years. So for today's session, I'm going to be going through basically what the FPPC, the Fair Political Practices Commission, and the California Attorney General provides for this training to be completed. I'm also going to, since I know most of you have done this training before, emphasize some areas of the law that have changed. For a lot of you, this is certainly something you've gone through before, so I think it's important to make sure that I underscore what has changed since the last time you did this session. Also, as a preliminary matter, because we're on Zoom, I'd ask that if everybody could mute their screens, and then typically I will take questions just throughout the presentation, but because we're on Zoom, I thought it'd be easier maybe every 20 or 30 minutes, open it up to questions. And that would probably be the best way to proceed, but it'll be a learning experience. There's a lot of folks here on the Zoom right now. So let's get started. So the session objectives today are to familiarize you with laws that govern your service and when to ask questions, encourage you to think beyond legal restrictions, and to help you comply with AB 1234 requirements. So the second of these is the most important, thinking beyond legal restrictions. And as I've emphasized before in these sessions and emphasized today, I'm going to be talking about, of course, legal rules that need to be followed under penalty and punishment by the law, but also to encourage you to expand past that and to, if you will, apply super ethical principles. I also want to be clear at the beginning that I am not suggesting that either I or the state of California, have some sort of monopoly on ethical behavior. And today's session is not to talk about personal ethics. It's first and foremost to talk about what the law says ethical behavior needs to be at a minimum. And I don't want anyone to think that I'm some ethical guru that's here to talk about, either religious or moral or, other principles that are of personal belief. This is a framework of legal ethics that have punishments if you don't follow them. And we encourage you to go beyond those as well. So basically it's 2 hours. I'll take questions, like I said, every 20 or 30 minutes. And when this is over, city clerk will email to you all a proof of participation, which we'd ask that you'd sign and turn back into the city clerk. And that will be a public record. And that is the proof that you have complied with the law. Folks want to do a PRA request, a Public Records Act request on the city, they can ask for who's turned them in, who hasn't. So that's one of the ways that all of this is verified, that folks are doing these sessions. And also, I get this question a lot, who has to do these? Basically, the city council, and then bodies that work with the city council. And the baseline is that if any of those city council bodies receive compensation or stipend in some form, then they need to do AB 1234. And so basically all the city commissions, advisory boards and bodies, and the city council need to do this training. So ethics law versus ethics. The law is the starting point for ethical analysis, and the law is what we must do. Just because it's legal doesn't mean it's also ethical. So keep in mind that I'm going to be emphasizing minimum standards Everyone has their own moral compass, their own ethics that they follow, and I'd encourage you to go above and beyond the law. The 4 core principles that the California Attorney General says that these sessions needs to cover are trustworthiness, respect, responsibility, and fairness. And these values promote public trust in government. And it also makes sure there isn't any appearance of impropriety. I think it's important to know that as you either continue or embark upon your career of public service, that there's both the ethical laws that we talk about today, there's your own personal ethics, and then there's public perception. And one of the ways our democracy works, especially on the local level, is if folks trust their local elected leaders and also those appointed to advisory boards, commissions, and committees. And so it's very important to make sure that there's also the appearance of propriety. So I'm going to ask you all to do a little test here in your head. Don't need to say the answers out loud, but ask yourself personally, do you believe that you're always ethical, mostly ethical, somewhat ethical, seldom, or never ethical? So pick one on that chart. And now the question is what do you think other people would think you are? Now, probably everyone in the room has picked, I am always ethical, I would assume, or mostly ethical. But you want to ask yourself, what would the public think? And the point of this is that you're now in public service, and we have to maintain trust with the public. And so that brings us to a lot of these principles are about transparency, where folks can see what the government's doing and the internal workings. So it's something to think about, both how you rate yourself and how you think others would perceive you. So here are some rationalizations for unethical conduct. Folks will often say it was necessary, ends justify the means. It was legal, which gets to my point about there's more than just the law in terms of ethics. Won't hurt anyone, can't be wrong, it's okay, I deserve it, etc. So that's the whole point of ethics, is that if it was an obvious choice, then we wouldn't be talking about ethical principles, we wouldn't have laws about it. Sometimes it's tough to make the right choice. So the purpose of ethics laws, of course, is to protect the public's trust in institutions and individuals that serve them, and also to make sure that local government works well. And perception's as important as reality. Your gut's not always a reliable guide. And one thing that I always like to emphasize in these trainings is the adage of if in doubt, send it out. Now, what that means is that if you have a possible concern about a potential ethical violation before a commission meeting or a council meeting, board meeting, and advisory board meeting, it's best to ask the city attorney, city clerk, city manager for advice on whether or not there's an ethical conflict. So if in doubt, send it out. And if you don't feel comfortable talking to City Hall, I will have some phone numbers and emails for you later in this presentation where you can anonymously ask the state agency that enforces ethical rules, the FPPC, for their advice. So if in doubt, send it out. That's one of the most important things I want you to remember as we go through these rules today. So as I said, there's these 4 principles, and underneath them, there's a number of actual specific instances where ethical rules apply. For trustworthiness, that involves bribery, conflicts of interest, contractual conflicts, campaign contributions. Respect involves Political Reform Act, Brown Act, Public Records Act. Responsibility is gift restrictions, misuse of public funds, gift of public funds, mass mailing restrictions. And fairness, protections against bias, due process, incompatible offices, competitive bidding, and anti-nepotism. So this is pretty much a roadmap of where we'll be going today and what we'll be talking about. So we're going to talk about ethics laws, what they cover, when you need to ask questions, and resources for further reference. And I like this quote from President Abraham Lincoln. Nearly all men can stand adversity, but if you want to test a man's character, give him power. So all of you attending today either have had or now will have power. You'll have power over decisions made in the city. You're going to have power on advice you provide to city council. And for city council members, of course, you have power over final decisions that can impact both the city, the region, and even the country at times. And so, as Abe Lincoln wisely pointed out, that's the real test. It's not theory, it's real now. So 4 groups of ethics laws. These are specifically the areas we're going to go over. Personal financial gain, personal advantages and perks, governmental transparency, and fair processes. So group 1, personal financial gain issues. The principle is that public servants should not benefit financially from their positions. This is somewhat of an intuitive idea, at least to Americans, that you shouldn't benefit financially from your position. And I think it's an intuitive idea to people all around the world in terms of the way a government should work. Fortunately, we're not plagued with institutional corruption at all levels of government in the United States. Of course, it is there, but I think we all get this idea. Public servants should not benefit financially from their positions. And examples of this are bribery, financial interest, disqualification, and revolving door restrictions. So specifically bribery. Again, I think we all understand what bribery is, but basically it's giving a benefit through using your power or authority as a public official in exchange for money or something else of benefit to you. And penalties, of course, are pretty strict. You can lose your office, you can go to prison, monetary fines, and of course, public embarrassment. A recent study, and this is actually still in the courts, the pandemic has halted a resolution of this. I just looked this up recently. Back in 2017, a former mayor of Palm Springs in Southern California was alleged to have accepted $375,000 in bribes from some developers. He has been charged with 21 felony counts. He's facing up to 19 years in prison. And the allegations are basically that this mayor was going to retire, not run again. And 2 developers in the Coachella Valley area told the mayor, hey, why don't you run again? And you can basically push through our development projects and we'll pay you for it. So they got him, the allegations say, a side job that would provide him quite a bit of annual money. They also provided him cash, the allegations say. And he's now facing prison time for that. So this is just a clear-cut example of bribes. And like I said, I just looked this up. The case keeps getting continued. It's not been resolved yet, but it's a pretty big case for California. Another case, City of Westminster in Orange County, California. 2017, a federal jury convicted David Vu, former planning commissioner, of just straight old-fashioned bribery. $15,000 in exchange for a liquor license. So this stuff does happen. I will say I worked with my law firm with a lot of different cities throughout California, and I've always been impressed with the high standards that Morro Bay follows. So I have not heard of, and I expect to not hear anything like this coming out of Morro Bay, but this does happen in cities across the state. Another case study, Moreno Valley, 2014. The council member pled guilty to accepting over $2 million from an undercover FBI agent to rezone property, sentenced to 5 years in prison. Bribery also has similar crimes: extortion, rewards for appointing someone to public office, or embezzlement, converting public funds or property to your own uses. So bribery is pretty straightforward. I think we all understand that one. Disqualification based on financial interest. This is when we start to get into some of the more, if you will, arcane laws and procedures where folks can make good faith mistakes, but the law still considers it to be something that you have to understand and follow. You can't participate in a decision if your financial interests are affected by it. Now, the law says, and this is basically a quote, you have a disqualifying financial interest if the decision will have a reasonably foreseeable material financial effect, distinguishable from the effect on the public generally, directly on the official or his or her immediate family. So what this adds up to I guess, rule of thumb is that if a vote you make on a decision or a decision you make as a public official will basically bring some financial benefit to you, usually it's a side benefit, because of the decision, then you're disqualified from participating. A classic example would be if you have a business in Morro Bay or some property in Morro Bay that is going to the city seeking a permit or some type of a license. If, as a public official, you have authority over whether that license gets issued or not, you need to abstain from voting or participating in that decision. Now, the mere existence of such a conflict, it doesn't mean that there's something wrong. It just means that you have to disqualify yourself from it. Obviously, you wouldn't be involved in public service in Morro Bay if you weren't involved in the local community. So these conflicts come up. A good example is that if a planning commissioner or a council member, if their personal residence is involved in some sort of rezoning or some sort of land use decision, depending upon the facts, they might not be able to participate in the vote. But there are some exceptions, and we'll get to those. So what kind of interest? What are we talking about? When do you need to disqualify yourself from voting? The general rule is that it's foreseeable reasonably, not for sure, but it's reasonably foreseeable, and it will have a material effect, meaning it will financially affect you or your family. And so that brings us to the 4-part test. And this is why when I say, if in doubt, send it out, if you're thinking that maybe a decision you're going to make or a vote you're going to take could financially disqualify you from participating, this is the test the law provides. And this is something that a city attorney, I can analyze with you, or you can ask the FPPC to review with you. And this is how the law looks at whether you have a disqualifying interest. Step 1, is it reasonably foreseeable? It'll have a financial effect, your decision. Like I said, a good example is if, say, there's a business that's seeking a conditional use permit from Planning Commission and it's your business. Well, obviously it'll have a financial effect on you. But sometimes it's not clear whether it will or it won't. So you go to step 2, will be material. And then step 3 is the big one. Will it be distinguishable from the effect on the public in general? A classic example of this is that obviously if the city is going to pass a law that affects the entire city, you can't disqualify all 5 council members from voting on that decision. Local government wouldn't work. So if it affects the public generally, then you're not disqualified from it. And then of course, step 4 is that absent an exception, if you've gone through these first 3 steps, then you're disqualified. Now I want to be clear that this happens in the routine course of decision-making. There's a conflict and the public official will just not participate. And that's normal. And it doesn't mean there's anything wrong going on. It's just you have to make sure that you don't participate in the decision. So specifically, what type of interests are we talking about? There's the $500 rule, where if basically it'll affect some income of yours of $500 or more, also your partners or your children, then you're disqualified. There's the $2,000 rule for business or real property investments. And this now is something that has changed. In regards to real property, if you're involved in a land use decision, the decision is going to impact an area near your real property, you have a couple of rules here, the 500-foot rule and the 1,000-foot rule. Now, it used to be years ago that we just followed the 500-foot rule. If your real property was 500 feet or more from whatever the decision you were making, for example, rezoning, then you were in the clear if it was other 500 feet away. Then the law changed recently the last time I did an AB 1234 training, I let everyone know that the law changed to, well, basically, if it probably will affect your property, regardless of whether it's more or less than 500 feet, then you probably want to disqualify yourself. That was a very murky standard. No one really thought it was a good idea because basically it just meant that, people to be cautious would always disqualify themselves. So now the law changed again. So now it's back to 500 feet or less disqualified in general. And the 1,000-foot rule is that there's a presumption of conflict if it's between 500 and 1,000 feet, if it's going to impact your business in some way. If it's more than 1,000 feet, you're probably okay making the decision. So I don't expect you all to, memorize these rules or to, rapidly apply these when you're making a decision. Just remember that if a decision comes to your board, committee, or commission, and it involves somehow your real property in the city, the distance of that real property from the decision you're making, the impact on the ground, affects disqualification. And if you have any questions at all, make sure you contact myself, or you can contact the city manager or city clerk, and we can review this with you. So it's 3:21. I'm going to go ahead and try our Zoom question and answer period if we have any questions at this point. So Dana, city clerk, and I talked about this before, and we thought that maybe we could start with just raising your hand up on the screen if you have a question, and I will stop share so we can see. So, okay, we'll start with Susan Stewart, and Dana, if you want to unmute Mrs. Stewart.
Hi. So my question is, so I own a business on Morro Bay Boulevard. I don't own the property, but I do certainly have a financial interest in my business. Does that mean as decisions come up, say with the new Bank of America building, and hopefully somebody will come and want to invest in that, do I need to recuse myself from those decisions on the Planning Commission?
It depends upon whether the impact is going to affect the public generally or not. And the rule has changed to that basically, and we're going to get to this, if it affects the public, 15% or more of the public, then no.
Okay.
You're not disqualified. And that's a really good question. This is exactly the type of issue that, I'm referring to. And so if and when this comes up, then absolutely reach out to myself, City Hall, and we'll do the analysis for you.
Perfect. Thank you.
Mr. O'Brien?
Yeah, good afternoon. Thank you. So my question was, if we are on a panel in which we know that we will be disqualifying ourselves for the vote, do we also have to disqualify ourselves from the discussion?
Yes. And I will be going over that in a few more slides. That's an area where the law has gotten stricter, where basically you have to not only not be part of the discussion, but you have to physically leave the room before the discussion starts. That rule change came about a while ago. I guess the FPPC thought that maybe people would do hand signals or facial gestures or something. I don't know, when a decision's being discussed, but and the rules gotten a little tighter where if you participate at any point during the meeting and you just happen to be absent when that item comes up, you haven't officially said, I'm leaving because I have a disqualification, you have to announce it at some other point in the meeting. The rule used to be that you just needed to leave if you were there when it started, but I'll get into that when we get to those slides. But that's a really good question, and you can't participate in the discussion.
Thank you.
Mr. Peck?
Yeah, I think my question has to do with most of us serve on different committees. In the case of the T-bid, the T-bid is expressly formed to collect money for the benefit of the hoteliers that are involved in that formation. I don't imagine that they're excluded from participating in decisions to how to spend that money to benefit their properties. So how is that the distinction made?
So in that situation, that's a really good question. The benefits that are being received are citywide. Now, of course, it's being received by the businesses, but the question is whether or not it's going to impact just one business or whether it's going to impact all the hotels and vacation rentals. And so, TBID itself is meant to benefit all the hotels and vacation rentals, motels, lodging establishments. And so therefore it's 100% basically the businesses, so it's fine. But if TBID somehow was going to propose that there is, $10,000 spent for one specific business by name, just that business, then that business owner would be disqualified from participating in the vote or discussing it. Okay, any other questions at this point? If you have one, raise your hand. All right, great. Well, that went well. Dana and I were, like I said, discussing how this would go. Dana, do you see any other hands up?
Therese, did you raise your hand? I thought maybe I saw you. No?
Okay.
Okay.
I am going to go back to my PowerPoint now. Okay, so we talked about the real property disqualification, and the location of the real property is really important. There's another type of interest, it's gifts. So there's a $50 520 rule. This is the second change that I want to point out from those of you who have done this before. It used to be the $50 500 rule. It's now gone up $20. So what the basic rule is that you cannot receive more than $520 in gifts from members of the public that you otherwise wouldn't exchange gifts with. So this isn't meant to ruin birthdays or holidays. This is supposed to be something where if you're getting a gift from someone that normally you wouldn't get a gift from, and it's probably because you're going to have a decision that affects that business or that individual, you simply can't take more than $520 in the value of the gift. And any gift that's worth $50 or more, you have to report it to the FPPC. And it's aggregate. So you can't get, 7 $100 gifts. It all adds up. Likewise, once the gifts aggregate go over $50, you need to report it. So this comes into play, for example, if a business person were to invite you to dinner and you did not have a relationship with them before you started your public service, and you don't normally buy each other dinner. If it's $50 or more, you need to report it. Now, to be clear, if you buy in your friend's dinner and they buy you dinner sometimes, or, you exchange gifts for Christmas or Hanukkah or your birthday, that doesn't need to be reported. It's if it's not already a gift-giving relationship. So an example of where this someone ran afoul of the law, City of San Marino, failure to recuse and disclose. Simon Lee was an alternate commissioner on the City of San Marino's Planning Commission. And prior to that, he was on the city's Design Review Committee. While on the Design Review Committee, he twice voted in favor of applications submitted by clients of his architectural firm. He has a financial interest in those individuals who came before the Design Review Committee. So he should have disqualified himself. He also failed to disclose those sources of income on his FPPC forms. And so he was fined $10,000. So this is the public generally exception. And this is the answer in part to Mrs. Stewart's question earlier. So even if there is a financial interest, it doesn't create a conflict if it's indistinguishable from the effect on the public generally. Now, what does that mean? That means at least 15% of the public is affected by the decision as well. This is the third change that I wanted to emphasize for those of you who have done this before. It used to be 25%. The FPPC changed it to 15%. So a good example would be if the city council or planning commission or TBID was proposing some rule, some new regulation that was going to affect half of the businesses under their jurisdiction, then the public generally exception applies. If it affects just 2 businesses and that's less than 15%, and one of those businesses is yours, then you'd be disqualified. And again, I want to emphasize there's nothing unusual about being disqualified. There's nothing wrong with being disqualified. In fact, I'd be surprised if over the course of the next year or two, quite a few of you didn't have a disqualifying interest. I mean, that's why you're involved in public service. You're active in the local community. So how long do you look back for disqualifying interests? You certainly don't have to go back, to the beginning of time. It's just 12 months before the decision. So for example, that individual that was on the planning commission in San Marino, those clients that he didn't disclose, those clients that came for permits that he had a financial interest in, they presumably, he made money with them within 12 months of that decision. So this here is also where you can get advice if you don't feel comfortable talking to the city attorney's office or city hall. You can call the FPPC, the Fair Political Practices Commission, and they actually can give you anonymous advice. You can also write them letters and email them. Keep in mind, if you email them, whatever you send to them could become a public record. But you certainly can call this number and not identify who you are, just ask a question if you'd like. And that's one way of getting a quick answer. So if you are disqualified, what does this mean? And this question came up too as well. First of all, you can't discuss or influence staff or your colleagues. You identify the nature of the conflict at the meeting. So let's say you have 3 agenda items and agenda item 2 is your conflict. Before agenda item 2 starts, but after you're done with item 1, because you're not disqualified, you would simply say, I can't participate in this decision because, I have a disqualifying interest. You could say, one of my businesses or my business is affected by this. And then you leave the room. And that actually is a relatively new rule about leaving the room, but it's important that you actually leave the room. And you don't count towards a quorum. So if a lot of folks are disqualified and the quorum's broke, there's a way to deal with that. You basically randomly pick a few people to stay, but that usually doesn't happen. So leaving the room rule. This is the 4th change that has occurred from the last time that I did AB 1234 with Morro Bay officials. The basic rule remains the same, that you need to leave the room. There are limited exceptions. If you own property that is the subject of the decision, you can turn back around and do public comment, but you can't be part of the decision making, or if you own or control the business. But the new rule, and this I guess is meant to stop people from being, if you will, a little sneaky, is that let's say you had 5 agenda items and agenda item 3 you were disqualified from. The new rule is that if you leave before agenda item 3 is called and then come back after it's over, you still have to say that you would have been disqualified if you'd been in the room when that decision came up. So this prevents people from leaving, say, 1 minute before the decision comes up. You still have to say something. And if you also join the meeting for the first time after the discussion and decision on this disqualifying item, you still have to make the announcement. This is a new rule, it's just the FPPC tightening up and making sure people communicate with the public about disqualifying interests. The question has come up, well, what if I miss the entire meeting? Do I have to say something at the next meeting? The rule's silent on that, so there's no requirement to do that. So penalties. If you have a disqualifying interest and you don't abstain from the decision, disqualify yourself from it, it can invalidate the decision. You can lose office, it can be a misdemeanor, monetary fines, attorney's fees, and of course the embarrassment. So that is all if you have a financial interest disqualification, which happens quite a bit. There's a special rule for contracts, and I want to emphasize this one. If the city is entering into a contract with your business or you personally, it just simply can't do that if you are involved in the contract. And if that happens, the contract is null and void. So the classic example is if a council member owns a business and enters into a contract with the city, typically those contracts can't be, they can't be executed. There are exceptions, of course, but the general rule is that it's such a strong presumption that you want to make sure that officials don't profit from their role in the government that you just can't enter into contracts. And it has its own government code. Attorneys refer to Government Code 1090 for this violation. A case study on this. This is the famous case that folks always talk about for Section 1090. 1985, went all the way to the California Supreme Court. Basically, a council member, through a middle person, sold land to the council member city. What had happened was the city wanted to do some development. The council member owned the land, and the council member sold it to a third party, and then that third party sold it to the city. And the court concluded that this transaction was all done to basically offload the council member's property to the city. The end result, and this is where 1090 is very strict, the end result was that the city kept the land and the council member had to give the money back. So there's a very strict sort of primitive justice with how the Government Code 1090 violations work. The city just gets to keep everything. So this guy obviously is sitting here sweating over it. This is my idea of what this council member looked like when this happened. There's also revolving door restrictions. You can't represent for 1 year folks going back before the same commissions or agencies or whatnot that you've been a part of after you've left. And best practices for this Section 1 is obviously avoid temptation to look at public service as an opportunity for financial gain. And in general, look at every decision and just ask yourself, does it somehow involve a financial impact on you personally or your family? If so, then you may need to disqualify yourself. And this happens quite a bit. Disqualifications occur. It's not a big deal as long as you just make sure you do the homework by talking to City Hall, myself, FPPC, and if there is a disqualification, you just don't participate. So that was Group 1. Now we're going on to Group 2, perks. So a key principle is that public servants should not receive special benefits by virtue of their positions. And the core law here is the Political Reform Act that we'll be talking about. So there's two kinds of perk rules: perks that others offer you and perks that you give yourself or use of public resources. So perks that others offer you. Like I said, you have to report any gifts of $50 or more on your Form 700 every year. And you also have a limit of $520 on gifts from anyone you don't normally receive gifts from. This changed, like I said, it used to be $500. It keeps going up every 2 years. There's exceptions for some kind of types of travel, and there also may be a disqualifying interest if it's over $520 in the prior 12 months. So remember that gifts don't always have bows. So if you get a dinner, you get tickets to an event, certain kinds of travel and lodging, that can be reportable. A good example is, again, if a business person takes you out to dinner and you weren't friends until you ended up on a city commission, board, or committee, and they buy you dinner, if it's over $50, you're gonna have to report it. Another example is tickets. This often happens in cities that have especially sporting facilities or stadiums in them. Often there'll be free tickets that are provided to different city officials. And for cities like Los Angeles or San Francisco, where there are big stadiums, the FPPC actually has a rule now where the city can set up a random distribution of tickets to staff members if they're regularly getting tickets from different venues. That hasn't been the case with Morro Bay, so we don't have a policy like that. But if that did happen, then we could adopt a policy for distribution of the tickets without having problems with gift reporting. Gifts also include family fun. So gifts to your family, immediate family, that's included. And also free tuition. That's not scholarships, but again, if somehow you're getting free tuition to a school and it's because of your position, then that's prohibited as well. Raffles and gift exchanges. So this is something where it's not that you can't participate in raffles. It's not that you can't participate in gift exchanges. It's just that if somebody sets it up so it's just city staff members that are getting some amazing gifts, then it needs to be treated as a Form 700 filing gift. If it's a raffle open to the general public, then this doesn't apply. If it's a bona fide competition open to the public, then it doesn't apply. But if it's somehow a business person has decided that they're going to provide thousands of dollars worth of gifts to the city, and it's just to city officials, then definitely the gift limit is going to apply. Other perks, no free transportation from transportation carriers. This is an odd one. I don't think this really comes up that often, but it dates back to the days when the railroads were very powerful. You also can't get fees for writing or speaking. Now, again, if this is your profession and this is what you normally do, then it's fine. But if suddenly, because you're now a city official, you're being offered $10,000 to come speak at an event, that's prohibited. And interestingly, California has this rule, but the federal government doesn't have as strict of a rule. And we do see often a lot of federal officials suddenly going out and giving speeches and being paid a lot of money for this afterwards to curry favor or even when they're in office. A case study from 2017, Contra Costa County DA, actually, the district attorney had to resign, pled no contest to a felony perjury charge. Basically, the county DA was accused of, and he resigned, violating the Political Reform Act 9 times. He used campaign funds for over 600 personal expenditures, and he was fined $45,000. So, you might think, well, this is a district attorney, you would think they'd know better, but this individual didn't, and definitely gotten a lot of hot water, sentenced to 3 years in formal probation and hundreds of hours of community service. Another example, Stone and Youngberg scandal. California regulators back in 2014, they cracked down on hundreds of public officials who were accepting meals, baseball tickets, brownies, other gifts from a bond company, and they failed to disclose them. Now, again, this is an example of where folks just didn't report it. There's nothing wrong with reporting gifts that you're receiving. Just remember that it can't be over $520 from the same source. And if it's over $50, you have to report it. Another case study, 2013, San Diego County and De La Rosa and Company. Again, over 200 public officials failed to report gifts from investment bankers, $24,000 in fines. Finance director was fined, planning director was fined. And the issue here is not necessarily the receipt of the gifts if it's under 520. It's that you need to report them. The penalties can be up to $5,000 per violation. You can end up paying your own attorney's fees, and you can end up paying other people's attorney's fees as well if they bring a private action to enforce the law and there is a conviction. So it's now 3:45. I think it'd be good to see if there's any questions. And also, I forgot to mention that at 4 o'clock, we will take a 10-minute break. So I'm going to stop sharing my screen and see if there's any raised hands. No questions? Ah, we have one from Mr. Gaffney. Dana, could you, oh, okay.
Got it. So me being a general contractor, am I unable to bid on like upcoming public works projects that are open to the public in Morro Bay?
Generally, yes. Sorry for that.
That's okay.
Specifically city projects, right? Not just any project in Morro Bay, but one where you'd enter into a contract with the city?
Oh, yeah, contract with the city.
I didn't
Yeah,
make sure that was
yeah,
clear.
that's
Yeah.
what I meant. Yeah,
Yeah.
city projects. Cool.
Yeah. Yeah.
All right.
Any other questions? All right, well, that's either good or bad. That either means I'm really connecting and everyone's learning a lot, or you're all just biding your time, but I'm gonna interpret it as the first one. Okay, I'll go back to screen share. Okay, so the next item to go over is the use of public resources. So the basic idea is that you will have access to material at City Hall, paper, pens, sometimes cars, and basically the personal use of public resources is prohibited, of course. I mean, it's common sense. There is a limited exception for incidental and minimal use. It's called the de minimis exception. And so the classic example is that if a personal call is received at City Hall, you can take the call. You don't have to say, oh, let me leave City Hall and do it on my own personal cell phone. But in general, though, you can't say go to the supply closet and just haul out a bunch of the city supplies and take them home and use them for personal use. Obviously, I think everyone understands that. This really gets play when folks are running for public office, and that becomes an issue of whether or not you're using city resources for political campaigns. But in general, I think most folks understand this rule. An example of this, expense reimbursements. You want to familiarize yourself with your agency's policies and limits, what kind of expenses you can be reimbursed for. It's important to document it. And of course, spouse, partners, friends, their expenses aren't reimbursable. Consequences, as you might expect, again, there's can be financial penalties, and there actually can be criminal penalties too. And it can also have income tax implications as well. A case study of this is the Sacramento Suburban Water District. And this example was actually so egregious that this is what led to why you're on this Zoom call right now. A number of years ago, the Sacramento Bee did an expose on the Sacramento Suburban Water District was grossly misusing public resources. People were using the agency credit cards for personal purposes, misreporting income, double dipping on expense reimbursements. And a lot of what they were doing actually was found to be not only in violation of law, but the claims were being made by the staffs and directors that they didn't know this was the law. So the response from Sacramento was to pass Assembly Bill 1234, which is why we're here. Assembly Bill 1234, AB 1234 training. An example, another one, LA Councilmember Richard Alcon. He was sentenced to 120 days in prison and banned for life from holding public office for conviction of perjury and voter fraud. This is an extreme example. Often it's financial penalties, but this guy was sentenced to 120 days in prison. And obviously his political career is over. What he'd specifically done was he'd exchanged political support for cash. He was arrested on suspicion of charging thousands of dollars to the city for motel rooms and calls to phone sex hotlines, used the city visa to cover 20 motel stays. This all added up to he'd spent a lot of money for personal reasons. So political use of public resources. This is an important one, and the FPPC keeps an eye on this. Individuals or the city itself can't use public money to support ballot measures or to support individuals in specific political campaigns. I do need to emphasize that the city and all public agencies, they generally have a duty to provide educational material on ballot measures and upcoming elections. It's just they can't abdicate one way or another. And so, of course, you'll see the city, providing informational material on different ballot measures, letting people know that elections are coming up, et cetera, but it can't take a position. Mass mailing restrictions. The goal of this is to make sure that incumbents don't have an advantage by sending out thousands and thousands of pages of mail to folks in the city for personal political reasons. There's specific rules on that. Basically, you can't send out more than 200 substantially similar items in a calendar month. And gifts of public funds. This comes up every now and then when the city enters into contracts. There has to be a basic fairness in a contract. You can't enter into a contract where it's so out of whack, if you will, that it becomes a gift to public funds. And that's in the California Constitution. So best practices, avoid perks and the temptation to rationalize about them. It's, of course, legally risky, and at a minimum, it's a public relations headache. So when to ask for help. Like I said, if in doubt, send it out. Whenever you have doubts, this is what the city attorney is here for. This is why I'm here, and I have a large law firm that I work with that supports me and the legal needs of the city of Morro Bay. If you have any questions, certainly email or call about disqualifications or any concerns about whether or not there is potential violation. So if you have doubts, please contact us, and don't wait for the meeting. Sometimes I do get questions either during a meeting or a few minutes before, and unless I can get all the facts, generally I'm going to be conservative and say disqualify yourself. If I can get all the facts ahead of time, I can do an analysis of it. And occasionally I'll even write a letter to the FPPC and ask them to weigh in, which has happened before. And if you get a formal opinion letter from the FPPC, then it provides you a shield if someone later claims that there was a disqualifying interest that you should have acted upon. So that brings us to group 3, transparency laws. So the basic idea of the transparency laws, or sunshine laws, is that everything you do as a public servant is the public's business, and the public trusts the process it can see. And so what this is going to involve is Form 700s, which most of you, because you've been in public service, have filled out, but you'll be filling them out now if you haven't before. The Brown Act, and then the Political Reform Act. So the Public Records Act, basically it allows the public inspection of records. The presumption is that every record in City Hall is a public record and can be reviewed upon request. There actually are a lot of exemptions and privileges, but the basic idea is that if it's at City Hall, the presumption is you can look at it, and our city clerk can certainly attest to all the Public Records Act requests that come in and that go through her office. And there's legal review at times on which ones can be released and which ones can't. And then there's the Brown Act. The Brown Act is open meeting laws, and the basic idea is that business has to be conducted in open. We don't want to have secret decisions. And so All business needs to be conducted with an agenda. The public knows about it in general 3 days in advance, and you have the right to comment. And I'll go into some more of those details. So what is a public record? Agendas and meeting materials, other writings prepared, owned, used, retained by the city, including electronic, and penalties for not releasing records when you should have can be adverse media attention, costs, fees if litigated. Like I said, there are a number of exemptions. The biggest one is usually litigation, pending litigation exemption. There's also personal privacy. If records that are being requested from City Hall have, say, Social Security numbers on them, of course, we're going to redact that. Personal phone numbers. There's also the deliberative process exemption, where decision makers are shielded from having their internal decision making until they reach a decision from having a huge spotlight on it, because otherwise it's a chilling effect. But on the flip side, most documents that are at City Hall can be and are released when people ask for them. Now, public records, and this is something I want to emphasize, public records, of course, include email, and there was quite a bit of, I guess, confusion, if you will, until 2017 when a case went to the California Supreme Court, City of San Jose versus Superior Court. This is an important legal principle to remember, that your personal email accounts, whether it's Gmail, AOL, whatever you might use, if you use it for city business, those emails can be public records that need to be disclosed. And what had happened was in the city of San Jose, there were quite a few communications that city officials were doing where they were intentionally, it appeared, using their personal emails instead of city email account. So they wouldn't have to turn over those emails. And the court said, no, if you're actually using your personal email for city business, then that's subject to disclosure. So what does this mean for an official in Morro Bay? What it means is that just definitely follow the council policies and procedures, which is that use your city email account for city business. And if you happen to use your personal email, if someone emails you, or you happen to use it here and there, if as a rule you always CC your city account, or you always forward that email to your city account, then you're fine. We can go ahead and look through the city servers for those emails if anyone asks for them. But if it turns out you have personal emails that are city business, unfortunately, the way the law works now is that if there's a request for those, worst case scenario is someone's going to have to look through all your personal emails to pull out those city ones. And I want to emphasize, this is as bad as it sounds if you don't keep your city business on the city emails. This has happened in a number of cities since 2017. One of my firm's clients in Los Angeles County, they had a big issue where one of the council members was using routinely their personal email. That council member then didn't run for office again, and the lawsuit continued. And the council and the city had this huge litigation going on with that council member, former council member, refused to turn over personal emails. There were subpoenas, etc. So this can get serious. And also, if a lawsuit's brought on the Public Records Act against the city, if the people who brought it win, the city has to pay their attorney's fees. So I just want to underscore that it's just a simple rule. Use your city email account, totally fine. And if you happen to use your personal every now and then for city business, by mistake, or someone just emails you, forward it to your city account, CC it, and you should be fine. And I also want to say, after all of that, to qualify as a public record, the writing must contain in some substantive way information relating to the public's business. So, of course, you're going to have emails that are, your personal ones that have nothing to do with your city duties. So don't worry about those. Financial interest disclosure. This is Form 700. Anyone who's been in public office in California is familiar with these. If you're not, welcome to the Form 700. This is basically transparency on what could influence decisions you're making. So when you take office annually, and then when leaving office, you have to fill out a Form 700, which is basic financial disclosures of financial interests you have in the city. They're usually pretty routine, and they're filed with the city clerk's office. You work with the city clerk, and they just become routine, but remember, you're gonna have to do that. One rule that doesn't come up that often, but something important to remember, is that, and this is only for elected officials, that if $5,000 or more is donated at that public official's request, then you need to report that to the state government. So this is to prevent favors being curried through council members. This doesn't happen a lot, but it's just one of those rules to point out. So best practices, assume all information is public or will become public, and don't discuss agency business with fellow decision makers outside meetings. These two rules relate to the first one, assuming all information is public. Remember, any email that you send, any document that you create as a public official, ask yourself, am I okay with this being released to the public? Am I okay with this even being on the front page of the newspaper? And it's usually not something that is bad, it's that it might be something embarrassing. And so just remember that, now that you're a public official, these documents generally are releasable if someone asks for them. And as for discussing agency business with fellow decision makers outside of meetings, I mentioned the Brown Act. And remember that the public has the right to see how decisions are made. The public has the right to comment on decisions being made. And so you shouldn't have a majority of your commission, committee, board, or council talking about city business unless it's at a city meeting. And of course, then the public can see how the decision's being made. So that's the don't discuss agency business with fellow decision makers. Okay, so I'm going to go into the Brown Act a bit more, but it is 4 o'clock now. So I thought we'd take a 10-minute break. And when you come back, I'll do Q&A. We'll reconvene at 4:12. And I'll see you all in 10 minutes. Well, welcome back. It is 4:12, so I will start up again. We are on the Brown Act. And I also, Dana and I were talking briefly at the break, and I wanted to be clear, I don't think I was, when I talked about Section 1090 conflicts, and especially Mr. Gaffney had asked about, I believe Mr. Gaffney's on PWAB, and whether or not he would be prohibited from bidding on city contracts. So the rule is that if the government official has some influence over the contract or the bidding or entering into it, then you just simply can't enter into it. And so it's possible that there could be some contracts with the city that specific boards would not have a 1090 prohibition on. So I didn't want to discourage anyone from public service by thinking they could never do business with the city. It depends upon the board that you're on and what authority that board has. So Mr. Gaffney, if there are questions about bidding on something, then definitely we can take a look at that and see if there's a 1090 prohibition. And that applies to anybody else that is involved in public service. I don't want there to be this disinclination to be a public servant because one thinks they can't ever do business with the city. It depends upon the authority that your board has. So to be clear on that. So the Brown Act. The Brown Act is the open meeting laws, and this term gets tossed around a lot. Basically, the Brown Act stands for the proposition that decisions must be made in public, that the public has the right to see how the sausage is made, if you will, and to also voice some input into the decision before it's made. And so that applies to both the city council and also the advisory boards, committees, commissions. What does the Brown Act actually mean insofar as what does it mean to have an open meeting? It means that a majority of the board, commission, council, or committee can't discuss the public's business that they have authority over unless they're at a noticed meeting. Unless they're at a noticed meeting where the public has 72 hours to know it's going to be and they can show up at it. A key concept is what constitutes a meeting, and it includes serial communications. And so that means that if you have one commissioner that talks to a second commissioner and it's on a 5-member commission, that's fine if you two want to talk. But as soon as you bring a third one into the discussion, that discussion needs to be at a public meeting if it's over stuff that you have authority over, because the public needs to see how you're reaching your decisions. And that also means that Commissioner 1 can't tell Commissioner 2, hey, this is how I'm going to vote. And then Commissioner 2 tells Commissioner 3, hey, here's how 1 and 2 and I are going to vote. That's a serial meeting. There are exceptions for certain kinds of events. One of the biggest exceptions is going to conferences, and there are some other ones as well. So what is a meeting? A meeting is any gathering of majority of the members of your body to hear, discuss, or deliberate upon any item within their subject matter jurisdiction. And means of communication. This is important. This is the rule that means that it's not just if 4 of the members of your commission are all having coffee talking about the agenda items that are coming up later. They're doing this in private. It includes, like I said, if 2 members are talking about how they're going to vote on something and one of them tells a third person or has a friend tell the third person. The whole point of this is to make sure that you don't have a meeting where an agenda item comes up and there's barely any discussion and everyone just goes down the line voting, and it's clear to the public that there was some sort of discussion or deal making done without public viewing and also the ability for the public to comment. So this is a basic sunshine law, the Brown Act. Meetings take place if a quorum receives information on, discusses, or deliberates on any item on which the body may legally act. Meetings must be within the city. It applies to the legislative body, i.e. the city council, and its advisory boards, planning commission, all other, if you will, sub bodies of the city council. Like I was saying before, usually it's 72-hour notice. Morro Bay has a tradition of doing 5 days notice for city council meetings, regular meetings. But the law says it's only 72 hours for regular meetings. If you call a special meeting, then you need to have 24-hour notice. And serial and rotating meetings are prohibited. Again, that's where you have one person talk to a second person, the second person talks to a third, the third talks to a fourth. And most importantly, this can occur over email as well. So you can't be having what's called a slow motion meeting. You can't, over the course of, say, 10 days, slowly have a majority of your commission or council talk about a decision through email. This doesn't mean social gatherings are prohibited, but you just can't talk about business that comes before your commission, board, committee, or the council. And also keep in mind that if a majority of your group is present at a restaurant or a social gathering, it's not automatically a violation, but it is if you start talking about the business that comes before your group, your body, your commission, committee, council. And so to prevent the public from thinking that basically you're up to no good, sometimes it's best just to avoid having a majority of your group at a social gathering together. It doesn't mean the law prohibits it, but this is where the perception issue comes up. So just something to keep in mind. You won't find 3 of the 5 council members all together, usually at a social gathering. And if you do, they're making sure that they stay away from talking about city business. And, it's a good rule of thumb in general for all of the council bodies, all of the groups, the committees, commissions, advisory boards, etc. I talked about serial meetings. Here's actually in writing how it works. And this is prohibited by the Brown Act. Like I said, it's kind of like a slow motion meeting. Member A contacts member B, talk about a city related issue, and then B contacts C, says what A and B are going to do. Boom, you have a majority that's deliberating outside of a public meeting. Same thing with what folks call the hub and spoke system, where maybe you have a staff member that talks to all or a majority of your commission or council and finds out how they're going to vote and relates opinions. Again, that's a violation of the Brown Act. This in the context also of that a minority of your group, so you and one other person in your commission, board, council, committee, you can be linked as long as it's a minority. And commonly you find council members doing that. So if you have two people on your commission or council, and there's 5 total, 2 of them can talk all they want about a specific issue. It's just they can't share it with a third. And so sometimes you'll have folks say, oh, I'm linked to, you know, this person on that issue, so I can't talk to you about it. So, you know, if you will, choose wisely on who you talk to in the minority on these decisions, because that's the person you're linked with. Otherwise, you're going to violate the Brown Act. Certainly this is something that gives rise to questions, and I will open up questions shortly, both for this and anything else we've covered to this point. New rule, this is the 5th or 6th new one I wanted to point out, Assembly Bill 992. This basically puts into law the advice that most city attorneys have been giving to cities anyways to date, which is that now it's officially the law that if one city official that is subject to the Brown Act is posting on social media, whether it's Facebook, Instagram, Twitter, what have you, the rest of the members should just not respond on that account. Because obviously you could have an entire meeting on Facebook if everyone joins on and starts posting comments. That was always best practices anyways to avoid doing this, but now the law is caught up with social media. And so just like when I was saying, you can't be emailing how you're going to vote on something, discuss it with a majority of your commission, board, council, or committee. Now the law specifically says that you shouldn't be doing it. I did add a slide in this year specifically for COVID-19 meeting rules. The very fact that we're sitting here on Zoom and we're not over at Vets Hall, the community center, doing our AB 1234 training is because of the global pandemic we're in. We're maintaining socially distancing. After I just talked all about the Brown Act and how you must have public meetings, the public has the right to be there at the meeting, the public has the right to question. You know, you might be saying, well, how come we're having all the city council meetings and planning commission meetings, et cetera, on Zoom? The governor issued an executive order in March of 2020. We're coming up on pretty soon the 1-year anniversary, that to prevent the spread of COVID-19, teleconferencing rules were relaxed. It's always been the rule that you can have 1 or 2 council members or commissioners teleconference into a meeting. But the rule was so strict that no one ever really wanted to do it before this executive order. If a council member or commissioner, board member, committee member wanted to teleconference into a meeting, wherever they were teleconferencing from, they would have to make that area open to the public and have the agenda published there. A good example of a few years ago, I had another client where one of the council members, for better or for worse, was stuck in Vegas and wanted to make the meeting. Leaving aside the fact that he was outside of the state, one of the compromises was that that individual wanted to teleconference in from the hotel to the council meeting. Of course, when that individual found out that at a minimum, you would have to make that hotel room open to the public, they decided not to do it. But, you know, that's an example of where someone was trying to use this teleconferencing rule. But now the governor has said you can do teleconferencing rules as long as the public can access through, as we do it, through Zoom, through the internet, and you also have the public comment ability. Hopefully we'll get back to regular conditions soon. I'm not a scientist. The pandemic will run its course, and we have vaccines coming out now, but I'll defer to the mayor, who's been giving the great COVID updates at the council meetings. But this is an interesting twist where this has gone, the Brown Act, during the pandemic. So what is not a meeting? After I've talked ad nauseum here about don't violate the Brown Act by having a majority of your group meeting and talking about city business, it's not a Brown Act violation to have individual contact with other members of your group. You can do that at public conferences. Just don't talk about the city business that you have authority over. You can go to other agency meetings. You can go to the county supervisor meetings. You can go to coastal commission, etc. All of you can show up. Again, I'd advise you don't sit by each other necessarily, or at least a quorum of you. And I'd advise that you don't obviously talk about the decisions that come before your group, but still you can all be there. Community meetings, social gatherings, etc. The key is just to ask yourself, am I basically having a mini meeting? It's a majority of my group discussing decisions we're going to make. If so, you need to do that at a public notice meeting where the public can observe and ask questions. Okay, I will now open it up again for questions. I'll stop sharing and go ahead and raise your hand if you have questions. Yes, Mr. Biles.
Yes, thank you. I have a question about bringing things onto the agenda for a public meeting and doing it so that you're not violating Brown Act restrictions. Sometimes I find that there will be issues discussed in former meetings that were not necessarily completed or concluded, and want to bring those back up to discuss. And it seems like it's a violation to bring them back up if they're not on the agenda for that current meeting, if you're bringing up a new issue, an issue that hasn't been concluded. What's the best way of doing that without, for example, going offline before the meeting to try to get it put on the agenda, which would be kind of a violation of the Brown Act in that case. So what do you say about that? It might be more of a parliamentary procedure rather than what you're focused on here, but I'm still kind of unclear on what my powers and obligations are in that regard.
Sure, that's a great question, and this actually comes up a lot. So if an item is not on the agenda, then there can't be sustained discussion about it. But you can ask questions of staff. You can propose that your group vote on putting it on the next agenda. You can ask staff to bring back a report. You can basically, the rule of thumb is have a few minutes of questions and answers with staff and propose a few things. But once you start discussing amongst yourselves, if it's not agendized, then you shouldn't do it. So a good example is that at a recent council meeting, Councilmember Addis proposed that there be a future agenda item on taking a look at recruitment for the advisory boards for a lot of the groups that you guys are all part of. And the council had not a discussion, but basically a vote on whether to bring that back. And they did bring it back, and it was on the council meeting this week on the consent agenda. And so, that was brought up, but it wouldn't have been proper to have a 30-minute discussion on it at that meeting, but they could vote on whether it comes back. And you can certainly ask questions of staff. Sometimes, folks will ask staff at a meeting, hey, I'd like to get a report on, A, B, and C. And if it takes, a bit of staff time, then maybe there'd be a vote on whether it's appropriate for staff to do that or not. Or it would just be, I want to see on the next agenda this item. and then, the group can vote on that. So you get a few minutes of question and answers. Just don't start discussing. Don't turn to your colleague and say, what do you think about this? What is your idea on how to solve this? But you can call for a vote on whether it goes on the next agenda.
So it would be for the next meeting, basically.
Yes.
Yeah.
Yes. And whoever on staff, whoever at City Hall works with your group on creating the agendas, there's always some specific procedure for how items get on the agenda. I'm most familiar with City Council agendas and how items get on City Council because, I intimately work with the council agendas. But, whatever group you're on, talk to the staff member that works with you. And the first step is to say, hey, can we put this on the agenda? And they'll walk you through the procedures. The second step is just bring it up at the meeting.
Okay. Great, thank you.
Any other questions? Raised hand and you get the floor. Yes, Mrs. Stewart?
Just a quickie, and I think I sort of know the answer. When I often will send a public comment, say to the city council about a topic that they have, and do it from my personal email because I'm not making that comment or whatever as a planning commissioner. It will go on the public comment that goes out. So is that appropriate, or would it, because I don't want to push around, gee, I'm Susan Stewart, planning commissioner saying this. I'm Susan Stewart, citizen saying this. So I use my personal email for that.
That's fine, because that email is being sent in your personal capacity.
Mhm.
And so when you get down to the basics of it, if there was a public records request for, all email communications, from Ms. Stewart, you could only ask for ones that involve your position within the city. So if you had an email sent on your personal account involving, your city business, your city official business, then yeah, that one's subject to it. But otherwise, the email that's received by City Hall would be disclosable, but they couldn't go into your email account for that.
Okay.
Any other questions? Yes, City Clerk Swanson.
I'm gonna mute myself. My question is about teleconference meetings. Is it a best practice, or is it legally required to take a roll call vote for any action being taken?
That is a good question, and that has been bouncing around the city attorney world for the last 10 months. There is no clear answer. So far, most cities aren't mandating that there's always a roll call vote if it wouldn't normally be required in a regular meeting without teleconferencing.
Okay.
But that question has come up on the city attorney forums, actually. That's there's so many weird legal questions that have come up with this COVID world that we're in. So that is a hot topic.
Thank you.
Any other questions? All right, I'll go back to, oh, wait. We have one? Mr. McClish? Oh. All right, I'll take that as no question. All right. Okay, agenda requirements. So what do you need to put on an agenda to comply with the Brown Act? A written agenda must be prepared for every regular adjourned meeting, and you can't discuss items that are not on the agenda. Except for, like I said, you have a few minutes of questions and answers you can ask. Stay on point. All matters to be transacted or discussed must be pursuant to the agenda. And again, if you think, well, gee, this is kind of hamstringing us making decisions or talking, the whole point of this is that if a member of the public is interested in what your group is doing, they can go check the agenda and say, aha, that item is going to be discussed. I'm going to be there. I'm going to listen, and I might make public comment. If it's not agendized and there's a big discussion on some item, that member of the public didn't know to show up. So that's the whole point of having the agendas. There always must be a reasonable period of time for public comment before or during consideration. Morro Bay has a tradition, which I think is great, of allowing more public comment than the law requires. A lot of cities just do a general public comment period at the beginning of an agenda, and that's that. Morro Bay actually does, at least for council meetings, a comment period at the beginning, and it's generally understood that if you want to comment on an agenda item and you can't stay, then you can talk about it then. And then Morro Bay always opens up a comment period before each item on the agenda. Interestingly, you'll see a lot of cities don't do that. They'll just do it at the beginning. And frankly, what Morro Bay does, I think, provides for better government, because if you have a 6-hour agenda and somebody said something, at 6 o'clock, and then the council's considering it at 10, it might not resonate as much. So it's nice that Morro Bay does that. But the point is that there has to be a time to comment before the agenda item's heard. And Morro Bay does that and more. You sometimes have an emergency item. If there is truly an emergency and the item arose after the agenda was published, you need a 2/3 vote to put it on the agenda. And it truly has to be an emergency, meaning that if you don't act on it at that meeting, that if you wait till the next meeting, there's going to be some catastrophic situation that occurs. So it's very rare that an emergency item gets put on the agenda. This relates to one of the questions that was asked previously. What are the exceptions to agenda requirements? Brief responses to questions, of course, statements or questions to staff, questions for clarification, references to staff or other resources for factual information, and requesting staff to report at a subsequent meeting. The general rule is that you have a few minutes that you can ask questions or make a few comments about really anything. It's just that it becomes a big problem, and there's a bright line on if it turns into a discussion. If it turns into a discussion between members of the committee, commission, board, or council about a city business, it needs to be agendized. And again, you go back to the basic rule that the public has the right to see how decisions are made. Public participation in meetings. So anyone can attend these Brown Act body meetings. Interestingly, you can't demand that folks say who they are. There can be no conditions to attendance. Morro Bay makes that clear in its council agendas that you don't have to say who you are if you ask questions. The public can record what's going on, and there, however, can't be disruptions, meaning that if someone is so disruptive at a meeting, a non-COVID meeting really, where we're over at Vets Hall, if somebody is being so disruptive that the meeting can't continue, they can be removed. A good example of what it means to be disruptive is that if somebody is sitting in the audience at Vets Hall and they hold up a sign that's on a pad of paper, and it's just in front of them, they can hold that there the whole time. But if somebody with a friend decides to unroll a huge banner in the front of the seating of the public where you literally can't see the council, that can be stopped. So the question is whether the disruption is causing the meeting itself to not function. There have been quite a few court cases in California where councils or groups, bodies, boards, commissions, committees have thrown someone out of a meeting, and the court had said, no, that's a violation of the First Amendment. So I'm glad to see that Morro Bay has not had this happen, where folks have shown up and started acting very rudely, but within their First Amendment rights. That has become a problem in some other cities. But as it stands right now, generally it has to be very, very disruptive for someone to be kicked out of a meeting. Closed sessions. Usually this applies to city council. It can't apply to all Brown Act bodies, but a closed session is the few times that a Brown Act body can actually meet without the public being there. And there are only 4 reasons for doing that: real property negotiations, litigation, labor negotiations, or personnel matters. And the reasons why all 4 of these can be done in what's called a closed session is because if the public were able to view what's going on, then presumably either the individual in the adversarial relationship with the city or the other party could also be there. And so it would tip the city's hand. And so that's why you can have these discussions in private. There are requirements to report out publicly sometimes decisions that are made. And generally speaking, once it's all done, like for example, if there's a real property negotiation and it's done, then it becomes a public record anyways. But it's kind of common sense, obviously, if say, for example, the city council is in the middle of a lawsuit and the litigators need to give an update on what the other side's doing and the strategy, et cetera. Of course, you want to do that in a private session. You don't want the other side in the lawsuit to be there listening at a public meeting. So for closed sessions, confidentiality applies. You can't discuss generally funds, budgets, salaries. And often you have to disclose in open session some of what happened if essentially a major decision and it was final was made in the closed session. So what are the penalties of the Brown Act failing to comply? The decision can be nullified. There can be criminal misdemeanors for intentional violations. There can be court actions to overturn it, injunction, mandamus, or declaratory relief. If somebody believes that there was a Brown Act violation by any of these groups, commission, committee, board, council, the law says that they have 90 days to challenge any substantive decision, meaning you have to send a written notice within 90 days, or if it's an agenda issue, you have 30 days. And the law also provides that the city then has 30 days to try to correct it. So that's why these letters are often called cure and correct letters. The city will get a letter from someone, from the member of the public saying, we believe that, the Brown Act was violated because there was a 30-minute discussion on something that wasn't on the agenda. Well, the city has 30 days to try to correct that, or a lawsuit could be filed. It is rare for this to happen in Morro Bay, but that authority is there for an individual to send a cure and correct letter to the city if they believe the Brown Act was violated. And then this brings us to group 4, fair process laws. As a principal, a decision maker, the public's expecting you to be impartial and to avoid favoritism. So what does this mean? Due process requirements are basically rules against bias, and essentially that you get a fair shake when you come before a decision-making body. The first question to ask yourself is whether it's a legislative decision or quasi-judicial. So most of the decisions that will be made by Brown Act bodies, the council, the commission, the board, or committee, most of them are what are considered to be legislative, where you're either making rules that apply to everybody, or you're advising the city council to make some rules that apply to everybody. Legislative decisions don't have as much of a due process requirements for it. Quasi-judicial is when you start having what people often talk about in regards to due process rights, of where you need a public hearing. Quasi-judicial is where your group is basically acting as a judge. The classic example is when somebody wants to get a conditional use permit. If somebody's trying to get a permit that is discretionary from the city, and the city can add conditions to the permit before it issues it, then that can be quasi-judicial. You need to have a public hearing for it. And when you have a public hearing, there's heightened standards of public participation, how it's conducted, et cetera. This generally will come into play mostly with planning commission and city council, the distinction between legislative and quasi-judicial, but it's something to keep in mind for how the process works. Fair process laws, due process in general, Impermissible bias is when you have a personal interest in the decision's outcome. And this can go all the way back to the beginning of today's session on disqualifying interests. You can have a personal bias or a factual bias. Keep in mind that the law provides that there's disqualifying interests where you can't participate. Other than that, a lot of these impermissible bias rules are ones where you need to ask yourself, can I make a fair decision or not? Ex parte contacts. This is something that's important to keep in mind. An ex parte contact is when you're involved in a quasi-judicial situation where you're acting as a judge, basically, and you've heard evidence or talked to somebody before the meeting. If you're acting as a legislator, if you're making rules, ex parte contacts are not something that needs to be disclosed. But keep in mind that if you're acting in a quasi-judicial setting where you're making a decision where you apply rules to two people that are in conflict, or somebody's asking for something, and you get evidence or talk to somebody before the meeting, you want to present that. You want to say, I had an ex parte contact with this individual, so everyone can see what might be influencing your decision. It can get a little murky and a little strained sometimes to figure out, is it quasi-judicial? Is it a legislative decision? When do I make the ex parte contacts? The basic rule is that if you're acting as a judge for something, then you want to disclose ex parte contacts. If you're just making general rules applicable to everybody, or advising the city council on rules applicable to everybody, then ex parte contacts aren't really an issue. Here's a few cases on due process, meaning the fair process. The Fairfield case, Hermosa Beach, and Los Angeles, Nasha. I wanted to just emphasize that this does come up where in Fairfield, two council members refused to disqualify themselves from an environmental hearing on an EIR for proposed development, even though they both publicly expressed their disapproval for the project. The court ruled that the applicants were deprived of a fair hearing. In Hermosa Beach, an applicant wanted to demolish a duplex and build a condo. Planning Commission upheld it, but the neighbors challenged it, saying the condo had blocked their views. There's a council member that refused to recuse themselves, even though he lived 1 block away. It might have obstructed his view too. It was considered to violate the Brown Act. And in Nasha, an applicant wanted to build a residential development, which went before the Planning Commission. One of the commissioners wrote an article attacking the proposed development that was published before the hearing. The project was denied. Again, the individual then said that there was bias. The Planning Commission was required to hold a new hearing. The takeaway from all of these is that if you have an opinion on something that's coming before you, and it's for a quasi-judicial issue, it's best to not be broadcasting that opinion ahead of time, because you're kind of boxing yourself into a corner. You need to keep an open mind. So it's important to just remember that principle of everyone has the right to have their fair day when they come before you, if you're going to be deciding on a permit or something to that effect. I also have a quote here too from the Fairfield case, where it says that a councilman or woman has a right to state their view on matters of community policy, and his or her vote may not be impeached because he does so. This is for the basic principle that for legislative issues, when you're actually making general rules or advising on general rules, of course you're going to have an opinion. That's why you're involved in public service. And, a lot of times when an issue comes before council or one of the groups, the folks will know where individuals stand. And that's okay. The fair process issue is mostly involved with quasi-judicial situations where you're acting as a judge. Okay, I wanted to open it up to questions. We're actually at 4:48, so we're almost to the conclusion of this. So I will stop share. If I have any hands coming up, I can answer questions. I'll take softball questions too. If anyone has like a really easy one. Aha, Mr. Peck.
This question has to do with ex parte contacts because of the nature of my business. I work in development. I sometimes run into commissioners or decision makers that feel uncomfortable meeting with the applicant ahead of the meeting, but feel more comfortable meeting with probably adversaries or others. Could you give us some guidance on that, whether that is advisable or practice or just kind of the way it is?
So commissioners can meet with both applicants and with folks that might be opposing some sort of permit being issued. But they need to, at the meeting, if it's going to be essentially a quasi-judicial or permits being issued, they need to disclose what they were told. They need to disclose what was discussed. Because think of it this way, if there are two sides to an issue where, you know, two folks are fighting over, like, should the permit be issued or not be issued? If there's a meeting ahead of time where one of the sides says, oh, but, you know, let me get your ear for 15 minutes and here are all of the great reasons why you should issue the permit, the other side has the right to hear those reasons. So that's why you say, yeah, I had an ex parte contact with, you know, blah, blah, blah. And, you know, maybe this is what they told me, or these documents they gave to me, et cetera. That's when you're having a public hearing, though. So I think the gold rule, the bright line rule is that if the issue coming before you is requiring a public hearing, it's agendized as a public hearing, then you need to be careful about the ex parte contacts. If it's not a public hearing, then generally it's what's considered to be a legislative decision, meaning that, you know, your opinion is your opinion and you can talk to anyone you want. Does that help? Okay. Any other questions at this point? Yes, Mr. Ingraffia?
Chris, yeah, as a planning commissioner, you know, I fully subscribe to the notion of if you have opinions, perhaps not to publicize them before the matter comes before the planning commission. But I also happen to sit on a board of directors of a land conservation group, a small group, and you know, undoubtedly that organization is going to publish certain opinions. And I'm wondering if, you know, that creates either a problem or a perception of a problem about this fairness and due process.
It would only be an issue if there was an opinion published ahead of time that is your opinion and it directly relates to a decision you need to make as a planning commissioner. So to be specific, if there are general principles of conservation that you might be supporting, that's not going to invalidate a decision made on probably a specific issue of conservation. But if there were strong opinions made on, you know, stop the development at, you know, this 3-acre parcel and there's active, you know, involvement in, you know, preserve this land. And then it comes to the planning commission, you know, how should we zone this? That could be a problem.
Okay.
So it's specific details for a specific issue that an opinion is taken on before, not principles in general. Does that help? Okay.
Very much, yeah, it does.
Yeah, Mr. Martin, you have a question?
Yeah, I'd like to hear your thoughts on something that I observed once. The legislative body had wanted to add something to the closed session agenda. They made the appropriate emergency findings that action had to be taken. And then when they reported back from closed session, they reported that no action had been taken. What are your thoughts on that?
Usually there is nothing to report out. If a final decision is made, meaning that a settlement is reached or some sort of negotiation has concluded, and by concluded meaning that the other party has already signed off on it and all you needed to do in the closed session was say yay or nay, then you would need to report it out. the best example of when something gets reported out is that if there's a closed session on initiating litigation, for example, if the council is deciding whether or not to basically sue like a developer, if they've decided they're going to file the lawsuit, then in that case, you might report out that you're going to file it unless it would create a disadvantage to the city. Reporting out might occur if, say, there's a lawsuit and the other side has already signed a settlement agreement, and then the council's deciding whether or not to sign it. In that case, if they decide to sign it, then you would report it out. But reporting out is not common, really. It's not common that something's reported out of closed session, if that answers your question. But I don't know the specific situation on what they were talking about, and I wasn't in the closed session. So I don't know what to say about that situation. Does that help a bit? Any other questions right now?
Barbara, do you have your hand raised?
Yes. Hi, Chris. Could you just please answer real quickly on the Form 700 disclosure requirements with respect to stocks, investments that are under IRAs and 401ks, if those are reportable?
I would need to look at the specific financial investment, but generally speaking, if it's not going to be involving the city itself, then you probably don't need to report it. But I mean, I can't say as a blanket rule whether you would or wouldn't, but you probably wouldn't need to report stuff in an IRA or 401k. I guess a good example is that if you had stock, say, in Disneyland, and you were on the Anaheim City Council where Disneyland's located, then yeah, you're going to report that. But if you had stock in Disney and you lived in Morro Bay, the Morro Bay city government is not going to be involved with Disneyland, so you wouldn't report it, even though it's a huge company, if that helps.
Okay, thank you.
And also, City Clerk Swanson has a lot of knowledge on Form 700s too. So I don't know. Do you have some thoughts on that, Dana? Or
My understanding is mutual funds and things of that sort do not need to be disclosed because you're not deciding specific businesses that you're investing in. But as you make choices about specific businesses or that might do business in Morro Bay, if the value is over $2,000, that would need to be disclosed. But we can certainly look at it carefully as Form 700s will be due April 1st.
Thank you, that answers it.
okay, I will jump back onto the screen share, and we're almost done.
I think we have one
Oh
more
wait,
question.
we have one more question.
I just have a quick
Yes,
question
Mr. Biles.
about your kind of relationship to the city, and in regards to when we decide, per your advice, to put it out when in doubt, and we call you for some issues and some clarifications of stuff. Does the attorney's clock start running for you to answer those questions, or and the city has to we rack up legal fees just by asking questions like that, or is that kind of not something that becomes a problem?
Generally, it does. Sometimes I'll write off the time depending on the situation. But yeah, generally, the clock will start running. But hello,
Hey,
you all can hear me?
Yep.
Okay, sorry, something glitched there. Yeah, generally, the attorney time will start running then. But depending on the situation, I might waive the time. But that's just part of city business. That the attorney's there to help out, and the attorney, of course, is going to be putting down the time too as well.
Sure. Okay. Thank you.
Any other questions right now?
I have a question.
Uh-huh.
Very briefly, in the public comment period, it said you cannot restrict anybody and you cannot demand from them a name or other identification. But it is traditional that we ask for your name at public comment. Is that not a contradiction?
You know, in the city council meetings, they don't ask for the name anymore, but generally people will provide it, but you don't have to. I mean, if someone says I refuse to give my name, you can't say, well, then you can't talk.
Okay, thank you.
I mean, it's customary at most meetings for folks to say who they are, but the First Amendment protects anonymous speech. And so if you want to show up at any council meeting anywhere in the state of California, you can just walk in and say, I'm not saying who I am, and here are my 3 minutes.
Thank you.
Yes, Mr. Swain?
Bob, can you unmute yourself, please?
There we go. Okay, sorry about that. So on public comment, they ask, on your slip, your name and what you want to talk about. So if you don't want your name on there, what do you put? Like anonymous -A? So when they call you up to speak, we'll have anonymous -A come up, or how does that work?
So at the council meetings, my understanding is that, at least when we're not in pandemic conditions, is that at the end, folks can just walk up and talk without having put their name on a slip. Now, they're not going to speak at the beginning of it, but I mean, I guess if you wanted to speak first, you could just put down Bob. I don't know. I mean, you could just put down anything. But I know Mayor Heading's been pretty fastidious about when we've been doing the meetings at Betts Hall. At the end, you can just walk up, at the end. You don't have to turn in a slip. The slips are just for efficiency, really. Okay, if there's any other hands up. All right, we have a few slides left to go, and then we are done. Okay, so we're on the slide now. Incompatible offices. Basically, you can't hold two offices that have authority over each other. The classic example is that you can't be on planning commission and city council at the same time. Competitive bidding requirements. All contracts the city lets that are especially public works, there needs to be competitive bidding for those contracts. State law defines what that means for public works. As for other contracts, it's local code that complies with it. When it's a professional, like say an accountant or an engineer, competitive bidding requirements are generally pretty relaxed, so you can pick someone that you think can do the best job. But when you have multiple companies that can do the same level of work, then it's usually an issue of price. And so the classic example is public works contracts. You have to do competitive bidding. Fair process laws continued. Disqualification requirements if a decision can involve family members. There's campaign contribution restrictions. This generally means that if you're on an appointed body and you're running for an elected position, that you need to be careful on who you take campaign contributions from, meaning if they came before your appointed body for a decision. And you can't solicit campaign contributions from specific employees at City Hall. Best practices, think fairness and merit-based decision-making. Keep politics separate from your relationships with staff. And essentially avoid committing or commenting before the public hearing. Sometimes folks already have an opinion before they make their decision, but it's very important to remember that even if you already have an opinion, if you box yourself into a corner by saying, this is how I'm going to vote, this is what I'm going to do, not only might it violate the law, but it's creating the public perception that the hearing doesn't really matter. So just avoid publicizing views beforehand. You can certainly say whatever you want after the hearing's concluded and discussion occurs. Resources for further reading. There's certainly a lot out there. One example is from the Institute from Local Government, a local official's reference on ethics laws. And questions to ask yourself. I think that it's good to go ahead and just follow the gut check in general. And if your gut's saying something might be amiss, then reach out to City Hall. Again, city attorney can respond to these questions. If folks are concerned about the city attorney spending time on this or money, like I'd said before, city manager or city clerk can answer your questions, or you can reach out to the FPPC. They can answer questions too. But a general question to ask yourself is, when you're making a decision and you're deciding how to act, if you're comfortable with it being on the front page of the local press, then it's probably okay. That's just a rule of thumb. If you think it's something that you'd want to hide, then there might be something fishy going on. So that's a good gut check. How would you want to read about it? Would you want to read about it on the front page? And how do you want to be remembered for your public service? So what we've gone over here today in these 2 hours are basically legal principles for the minimum for ethical behavior. Everyone has their own moral compass. Most of you, if not all of you, have a higher set of ethics than what the law is going to require, and I encourage you to follow those. And when in doubt, ask and ask early. And now we've reached the point where thank you for being here for 120 minutes. AB 1234 is done for 2 years. You have a proof of participation certificate that the city clerk will send to you all. I'd ask that you'd sign it and return it to the city clerk. It will be a public record. And I would encourage you all to go above the minimum of these 2 hours every 2 years in terms of your education on these matters and all matters of public service. And I now will be open for any more questions you have. And if you'd like to log off, unless Dana has some announcements to make, this will conclude at least the mandatory part. And I'm going to hang out for any questions that any of you may have. And thank you all for being here.
Yes, thank you all very much for attending. And we will email you a certificate of completion tomorrow that you can print and sign, and please return to the clerk's office. Thank you very much.
You're welcome.
Thank you all.
Thank you.
Thank you, Chris.
My pleasure.
Appreciate it, Chris, so much. Thank you.
Thank you.
Chris.
Yeah,
Thank you,
thanks,
Dana.
Chris.
Thanks all.
Thank you. See ya. Boink.